and ministers of the government of the Federation or officers in the public service of the Federation. 3. The Prime Minister shall submit for approval to the National Assembly nominees for ministerial posts only from amongst its members who possess the requisite qualifications and cognate experience for the ministries. 4. There shall be a council of ministers whose function shall be to work with the Prime Minister in the running of the government and in all affairs of the Federation. 5. The Council of Ministers shall consist of the Prime Minister, the Deputy Prime Minister, and the ministers as approved by the National Assembly. The body shall comprise and be limited to a single-digit number of members. Government ministries shall be rationalized and configured in compliance with this stipulation. 6. An increase beyond the single-digit stipulation must be made only by a special request by the Prime Minister for approval by a resolution of the National Assembly through a vote of not less than 4/5 of all elected members. 7. Approval of additional ministerial appointments granted under this article shall lapse with the subsisting administration unless subsequently renewed by the succeeding National Assembly. 8. The Prime Minister may assign to himself or any other minister of the government of the Federation responsibility for any business of the government of the Federation, including the administration of any department of government, but with such allocations and designations as subject to the prior consent of the National Assembly. 9. The Council of Ministers shall rely entirely on the civil service for all technical advice and support, thereby precluding the proliferation of any other parallel bureaucracy in the form of advisors. All subordinate appointments and designations below ministers shall be made from the ranks of civil servants with permanent tenure in the public service. The Federal Legislature. A lot of you are asking, how are they going to do all of this before October? How did they change the Nigeria national anthem in just 2-3 days? These guys are up to something, and you better open your eyes. You better keep your eyes peeled. I'll continue. I know it's a long read, I told you, but I'm going to read all of this just because I want to leave it here, right? Chapter 3:9. Federal Legislature. 1. There shall be a National Assembly for the Federation of Nigeria. It shall be a unicameral legislature. So they are now going to get rid of Senate, get rid of reps. Just going to have one National Assembly now. There's no rep, there's no Senate anymore. So hang on. Somebody said, are they going to do all of this? Baba? It is either this is fake news they want to use to distract all of us again, just like this national anthem, or indeed they are up to something. And I am. My money is that they are up to something. They are. Just pay attention. So somebody actually made this proposal. Don't get it wrong. Go. So the news then is that it is going to end up in the National Assembly, and the National Assembly is going to kind of deliberate on it and sack themselves. Anyway, in fact, hang on. There's something I want to show you. The author. So it's called The Final Draft by Akin Fakponda. I've been trying to look for that Akin Fakponda all this while, but I haven't yet. I haven't seen him. So I'm trying to get his image so that I can bring you the person, the brain behind this from 2021 until now, okay? So the federal legislature, according to them, is so it said the National Assembly is going to be a unicameral legislature. So the National Assembly shall consist of members drawn equally to represent the respective regions of Nigeria. The number per region and the total number not exceeding 180 at any one time shall be as determined by resolution of the National Assembly. National Assembly members are representatives of their respective regions and as such, not subject to control and direction at the federal level. Accordingly, they shall all be compensated, remunerated, disciplined, or recalled only through such provisions as may be authorized by their respective regional territorial legislatures. There shall be a speaker and a deputy speaker of the National Assembly, both of whom shall be elected by the members from among themselves. 5, the principal function of the National Assembly shall be the enactment of laws for good governance and effective value for monitoring of the operations of the federal government. 6, subject to the provisions of this Constitution, the National Assembly may regulate its own procedures, adopt rules and procedures regarding the organization of its work and of its legislative process. So, notwithstanding the provisions herein, the judiciary shall have powers to inquire into compliance with stipulated rules and processes. So, the federal judiciary. 1, the federal judiciary shall, to the exclusion of any other court, have original jurisdiction in any dispute between the federal and the region, insofar as that dispute involves any question, whether of law or facts, on which the existence or extent of a legal right depends. 2, in addition to the jurisdiction conferred upon it, the federal judiciary shall have such original jurisdiction on all matters in the Federal Capital Territory as may be conferred upon it by any act of the National Assembly. 3, provided that no original jurisdiction shall be conferred upon the Supreme Court or any Federal High Court with respect to any civil or criminal matter. 4, there shall be a Federal Supreme Court of Nigeria. The Supreme Court of Nigeria shall consist of A, the Chief Justice of Nigeria, and B, such number of justices of the Supreme Court not exceeding 9, as may be prescribed by an act of the National Assembly. 5, for the purpose of exercising any jurisdiction conferred upon it by this Constitution or any law, the Federal Supreme Court shall be duly constituted if it consists of not less than 5 justices of the court. There shall be 6, there shall be a Federal High Court in the capital city of each region and in the Federal Capital Territory. The Federal High Court shall consist of A, a Chief Judge of the Federal High Court, and B, such number of judges of the Federal High Court as may be prescribed by an act of the National Assembly. 7, notwithstanding anything contained in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly, the Federal High Court shall have and exercise jurisdiction to the exclusion of any other court in civil cases and criminal matters. So 311, establishment. Thank you very much, Dora. Give me a sec, okay? I want to be sure that my audio is still pretty much like all right, so that I'm not just like there getting soaked in it and all of that, okay? So APC, Egbe, they are up to, especially Tifnumbu and his gang, they are up to something. And that something is going to actually tell any moment from now, okay? So they are pushing regional system. Regionalism is not something somebody drafts a constitution for. Regionalism have to come from the point of, the ethnic nationalities in Nigeria, the tribes, the ethnic, and the rest of them actually being notified. Then they will then submit their own article of participation, article of independence, or article of union or something. That is when you are going to then draft out a constitution from that. When people say, this is the type of government we want, they have to sit and discuss it. But these guys are up to something. To change the national anthem of Nigeria, you will need the 2/3 State House of Assembly of 2/3 of 36 State House of Assembly. to third of 36 state House of Assembly in Nigeria is 24. So you will need 24 states in Nigeria, State House of Assembly, to deliberate and vote and pass the amendment before you can change the national anthem or pledge or anything. But Tinubu and his gang, they sat, they wrote it, they did all of that, and then they passed it. They said the rest of you should start singing it. So for them to start pushing something like this again, it's either they are pushing for a distraction or they are testing the water for something as well. I don't really believe in this, but it is Nigeria, where you just like, okay, did they just sit down and write to sack themselves? Remember when I told you that if you ask these people to actually either restructure Nigeria or return Nigeria back to regional system of government, you are practically asking these criminals, right, to do what is right and then sack themselves. You understand? Like, oh, Tinubu and gang, we want you to do what is right. Are you with me? We want you to do what is right, but doing it means from Tinubu to all your National Assembly members, to all your state governors, to all of your House of Assembly and the rest, once they do the right thing, right, they will then have to sack themselves. And do you really think these ones will do that? No, they won't. So they are up to something, but let this be on record anyway. Here, let's continue. We have just about maybe 7 or 8 pages more, and I'll just close it, okay? So yeah, they said the establishment and the this is the one I want you to also take a look at. The establishment and composition of the security services, right? Whatever this even mean, right? But here, 1, there shall be an armed forces, security and intelligence services, and such other bodies for the federation as may be established by an act of National Assembly. 2, the composition of the officer corps and the other ranks of the services shall be by regional territorial configuration, such that any service stationed in each region shall, in respect of the other ranks, be exclusively composed of the citizens of that territory, while the officer corps may, for the purpose of technical specialty and operational cohesion, admit up to 10% of citizens from other regions, provided that the head of such regional command shall be an indigene of that region. That is to say, let everybody handle their own security and safety. Makes sense, Abi? 3, the headship of armed and security services shall be rotated amongst the regions, and no one region shall head more than one arm of these forces, concurrently. 4, policing and internal security services shall be decentralized, with the federal, regional, sub-regional government and communities having the right to set up and maintain their own services, such that each level of government shall have exclusive jurisdiction and control over its own territory with regards to their respective powers and functions. 5, there shall be an Inspector General of the Federal Police Service with a guaranteed non-renewable tenure of 6 years, except through an earlier resignation or by removal, only on the account of gross misconduct resolution by the 2/3 66% majority vote of elected members of the National Assembly. 6, the office of the Inspector General shall be rotated amongst the regions, and the headship of any contingency of the Federal Police Service stationed in any region shall be by an officer who is a citizen of that region, of the region. 7, the Inspector General of Police shall always act in concert with the Premier of a region and execute all lawful directives. So 3.12, management of resources and revenue. 1, constituent unit of regional territories shall control and retain all resources and revenues falling within its natural jurisdiction, but shall only pay both federal and regional taxes according to laws. 2, for the avoidance of doubt, the entire property in and control of all minerals, mineral oil, and natural gas in, under, or upon any land in Nigeria, or in, under, or upon the territorial waters of Nigeria shall vest in the government of the regional territory and the constituent units bearing such resource. 3. The National Assembly may, with the concurrent regional legislature, make laws for Nigeria or any part thereof with respect to the taxes on the income and profit of individuals and companies. So 313, fiscal arrangements. 1. There shall be a first line charge account, which shall be 10% of the total revenue accruing to the governments of the Federation, federal and regional, which shall consist of A, 8%, which shall be applied towards the provision of the basic social economic in disadvantaged areas across the country. B, 2% to finance a special rehabilitation fund for past devastation arising from acts and omission of the Nigerian nation states. So 2, the first line charge account shall be administered by a commission consisting of 1 member each, representing and appointed by each regional government, and a member representing the federal government, respectively. 3, the balance of 90% shall, for the purpose of sharing among tiers of government, be reckoned as 100% and shall be distributed as follows. C, 55% derivation. D, 30% to the distributable pool account. E, 15% to the federal government. 4, funds accruing to the regional territories from the distributable pool accounts shall be applied primarily to financing the region's capital expenditure necessary for infrastructure. Recurrent expenditure of the regions shall be funded from internally generated revenue. 5, the regional territories or sub-territories shall be responsible for the collection of value-added tax, VAT, and the revenue derived therefrom shall be retained, provided that 10% of the accrual shall be paid as tax into the first line charge accounts. 314, remunerations and compensations in the public service. There shall be a single scale of salaries and allowances for the Federal Public Service of Nigeria to be periodically presented to and approved by the National Assembly. 2, for the avoidance of doubt, there shall be no other form or formats of remunerations or compensation outside the stipulations of the Unified Federal Public Service Scale of Salaries and Wages, unless expressly approved by 2/3, 66% votes by elected members of the National Assembly. 3, the regional territories shall have powers to determine and set the salary structure of their respective public services. 315, anti-corruption measures. 1, government at all levels shall abolish all corrupt practices and abuse of power. 2, all public officers' asset declaration and all forms of affairs shall be available for scrutiny by the public and shall be publishable without hindrance in the mass media. 3, all investments held by every public officer in any profit-making enterprise shall be held in a blind trust, while tax clearance certificates of all public officers shall be available for public scrutiny and shall be publishable by the mass media. 4, no public officer shall operate a bank account or own any form of movable or immovable asset outside of Nigeria, unless fully disclosed prior to or after the period of public service. 5, all gifts in whatever form made to the public officer or to his or her blood relations shall immediately be disclosed to the appropriate institutions of government that shall be designated by the National Assembly or the regional legislature. Retention or compulsory donation to the state by the public officer shall be at the discretion of such institutions whose decision shall not be interfered with by any other person or body. 316, provisions for the judicial adjudication of corruption and betrayal of trust matters. 1, in cases of corrupt practices, criminal breach of trust, public trust, plundering of public funds and resources, with prima facie case having been established by the court of original jurisdiction, the doctrine of the accused being assumed to be guilty until proven innocent shall subsequently apply. Not innocent until proven guilty. You are guilty until proven innocent. I like that. The guilty until proven innocent doctrine being an extraordinary provision to cure an extraordinary malady of the times shall expire within 30 years after the effective date of this constitution. So part 4, regional territorial administration. The territory of Nigeria shall be reconfigured into regional territories as the basis of the federation. So part 4.1, processes and procedure for transformation. 1. Members of the respective regional territories as existing at the commencement of this act are as follows: North Central Region, Benue, Kogi, Kwara, Nasarawa, Niger, and Plateau. Northeast Region, Adamawa, Borno, Bauchi, Gombe, Taraba, and Yobe. C. Northwest Region, Jigawa, Kaduna, Kano, Katsina, Kebbi, Sokoto, and Zamfara. Southeast Region, Abia, Anambra, Ebonyi, Enugu, and Imo. South Region, Akwa Ibom, Bayelsa, Cross River, Delta, Edo, and Rivers. And the Southwest Region, Ekiti, Lagos, Ogun, Ondo, Osun, and Oyo. 2. Subsequently, after the commencement date, but within 12 calendar months thereafter, the respective state assemblies shall meet individually, jointly, and severally consult to prescribe the processes and guidelines to be applied towards the institution of the suitable governance structure for their territories. 3. Ethnic nationalities, ethnic subnationalities, and peoples within the territory enumerated in sub-article 1 of this article shall have the right to maintain, reconfigure or merge, or establish new administrative units, and or adopt any suitable nomenclature as may be determined by the respective state assemblies without any direction from any other authority. 4. The quest to exist as a region by any ethnic nationality or subnationalities shall be subject only to the following stipulations. A. Proof of economic self-sustainability of a contiguous territory. B. Demonstrable capacity to contribute shared contributions to maintain federal government. C. Proactive plans for the exploitation and development of local resources and potentials. D. Intent to collaborate and cooperate in pursuit of self-development. And 8. In fulfillment of the above requirements, there will be an exit clause for sub-ethnic nationalities of peoples and regions who desire to switch to an independent sovereignty, subject to the following. A due notice by proposed sovereign political zone. B, a specified period of consultations and then referendum to ascertain the wishes of the citizens of the said political zone, approving their voluntary desire to be a sovereign territory. 3, the right of any ethnic nationalities or people to create, merge, or reconfigure the existing states within their respective regions shall be exercisable under the following procedures. A, the demand for reconfiguration has been approved by a 2/3, 66% majority of the members of the council of the ethnic nationality or people in the area concerned. B, The State Assembly that received the demand shall organize a referendum within 6 months to be held in the area of the ethnic nationality or people that made the demand. C. The demand for the statehood configuration is supported by 2/3 66% majority vote in the referendum. The regional government will transfer its powers to the ethnic nationality or people that made the demand. And E. The newly created or reconfigured sub-regional entity by the referendum without any need for application automatically becomes a member of the region concerned, and then the federal government and the Federal Republic of Nigeria. F. The newly created or reconfigured sub-regional entity by the referendum shall have equal rights and obligations as all others within the region and in the Republic. G. Where the concerned peoples and states within the region fail to reach agreement on any issue pertaining to this exercise, the regional legislature shall decide such disputes based on settlement patterns and the wishes of the people concerned. So 4. Also, after the commencement date or at any other time in future, ethnic nationalities and peoples across the regional territories enumerated above have the right to express the wish to move and be merged across regional but contiguous borders. 5. The right of any ethnic nationality or peoples to create or merge territories contiguously across regional borders shall be exercisable under the following procedures. A. The demand for regional cross-border reconfiguration has been approved by a 2/3 66% majority of the members of the Council of the Ethnic Nationality or people in the area concerned, and the demand is presented in writing to the 2 or more regional governments concerned. B. The government of the concerned regions that received the demand shall jointly organize a referendum within 6 months to be held in the area of the ethnic nationality or people that make the demand. C. The demand for cross-border configuration is supported by 2/3 66% majority vote in the referendum. D. The 2 or more regional governments concerned will transfer its powers to the ethnic nationalities or people that made the demand. And E. The cross-border configuration by the referendum without any need for application automatically becomes a member of the sub-regional entity within the region concerned, and then the Federal Republic of Nigeria. F. The newly created or reconfigured sub-territorial units by the referendum shall have equal rights and obligations as all others in the region and in the Republic. G. Where the concerned regions fail to reach agreement on any issue pertaining to this exercise, the National Assembly shall decide such disputes based on the settlement pattern and the wishes of the peoples concerned, with emphasis on consensus. H. The decision of the National Assembly may be the subject of an appeal to the Federal Supreme Court. The decision of the Federal Supreme Court shall be final. So part 4.2, basis of regional government. Regions shall have the following powers and functions. A. Every region occupying a contiguous territory shall be entitled to separate regional constitution fashioned to suit our worldview and outlook of living and development aspirations. B. To establish a regional territorial administration that best advances self-government, a democratic order based on the rule of law to protect and defend the federal constitution. C. To establish any administrative unit constituted based on the principles of federalism and self-determination that is well suited to all constituent ethnic nationalities in our territories. D. The regional and or sub-regional legislatures shall have powers to make laws for the peace, order, and good government of the region, state, or any part thereof with respect to all concurrent and residual matters not expressly stated in the federal constitution. E. To establish and administer regional territorial security and maintain public order and peace. F. To establish regional territorial supreme high and first instant courts. The particulars of these courts shall be determined by laws enacted for the purpose by the regional legislatures. And G. Regional supreme courts shall have the highest and final judicial power over regional and sub-regional matters. They shall also exercise the jurisdiction of the Federal High Court in any civil and criminal matters. Part 4.3, drafting and enactment of regional constitutions. 1. The respective state assemblies shall act jointly and severally to prescribe the processes and procedures for the drafting of regional constitutions and getting the peoples of the territory to ratify same. Prior to its registration with the National Assembly,